Good
morning, Ms. Lerner. Ms. Pennell.
Morning.
Good morning, Chief Justice Marshall. Good morning, Associate Justices. May it please the Court, my name is Carleen Pennell, and I represent Sean Dwyer, who is the defendant and the appellant in this case. This case is before this Court following the allowance of my application for direct appellate review. In that application, I argued that the Bishop Protocol, as subsequently modified by this Court in Fuller, needs to be replaced with a workable and constitutionally permissible and acceptable alternative, because as this case shows, and other cases that have come before this Court have shown, the heightened relevancy requirement in Fuller has deprived defendants of exculpatory information and privileged records that otherwise could have made a difference between a guilty and a not guilty verdict.
Ms. Pennell, isn't that always the case when there's a privilege?
Always the case that
If a witness consults an attorney and it's covered by the attorney-client privilege, the defendant doesn't get access to that?
that is true. But
in other words, if anything, hasn't the Bishop Fuller Protocol given defendants greater rights than they would otherwise have?
I don't necessarily agree. I think the privacy rights we're talking about are statutory. I know there's been some suggestion that they might be constitutionally based, but the underpinnings of the right to a fair trial and due process, the right to confront a witness and to cross-examination, has always been a fundamental constitutional right of a defendant.
Why doesn't that apply in the attorney-client, to the attorney-client privilege?
I think the reason for the attorney-client privilege is the public policy of that is you have to have freedom of being able to consult with your attorney, that the protections that you need in order to consult with your attorney are the right to speak to him freely, so that you can get effective representation.
I understand that, but it can't be from a constitutional point of view that there's a difference between a common law created privilege and a statutory privilege, and I'm simply trying to address your argument that says, that even though there's a privilege, that gets overridden in some kind of way by a claim of a right to a fair trial.
Well, I think you have to look at the basis and the policies for why we have the privilege on medical records in the first place. And it's obviously important public policy reasons to encourage complainants who have been the victims of rape to be able to seek counseling and to be able to feel that counseling is going to be confidential. However, I don't think...
If you had a choice to refashion the test, what would you do? Would you go back to Stockhammer?
I've reviewed the 3 protocols that were submitted to this Court. I think the one that I most closely agree with is the one that CPCS also agrees with. I think if I'm to change the protocol...
Which one is that?
That's option C. Which is the closest to...
Which is the closest to Stockhammer.
That's correct.
Could you tell me in what significant way C differs from Stockhammer?
I think, first of all, it requires that the Stage 1, the relevancy determination, has to go through what this Court's now announced in Lampron as the 4 or 5 stages that you have to satisfy in Lampron.
Okay, but Lampron now is we redefined the law, so that's a given. But what else?
I think that you have the in-camera review of the trial judge, and there's an additional showing that must be made in order to get access to those records. That is now a very heightened standard under Fuller that didn't exist in Stockhammer. This Court in Commonwealth v. Bishop warned that there was a danger in requiring a defendant to make too substantial a showing to justify a piercing of a privilege. And I think this case clearly shows the perfect example of how that danger has come into fruition.
Well, let me put it this way. I mean, I think that what everybody acknowledges is that we have placed – it seems to me that the privilege is either constitutional or not constitutional, and, how you try to rescue little pieces of it by asking the defendant to come forward with something that the defendant cannot possibly know seems to me to be an exercise in futility.
I agree. I think in response to Judge Graney's question, if I could change the protocol, the one significant thing I'd change is that a defense counsel, and just a defense counsel, not the defendant, would get access to the records as an officer of the court, subject to strict protective orders, obviously, Because
If the privilege is not constitutional, why are we essentially legislating here? In other words, my fundamental problem is you have a privilege. If you don't have a privilege, aren't you back to all the normal rules about the circumstances under which any third party has to produce evidence in a defense in a criminal case?
Oh, absolutely. When I say that I would change the protocol so that records would now be reviewed in camera by defense counsel, I'm only speaking with respect to privileged records. I think this court has made clear in Oliveira that if there is no privilege, that this whole entire protocol, whether it's Bishop or Fuller or something else, doesn't even apply. That once you've met the relevancy standard, the records go directly to the defense counsel. And that was one of the errors in this case. There was a motion to compel access to the therapy records, so it's a stage 1 of Bishop. The motion judge looked at it and said, I'm going to give subpoenas out to 3 different hospitals, but I'm not even going to issue the summons with respect to records to Dr. Prudence Allen and Jeannie Michaels because they determined, based on a medical record, that these people were governed by Chapter 233, Section 20B. Now, I think this case made clear in Oliveira, if you meet the relevancy requirements under Stage 1, the summons goes out and you have to wait for a privilege to be asserted because you can't automatically assume.
Can I go back to option C for a minute, which everybody seems to agree is the closest thing to Stockhammer. One of the last steps, and I don't know why we're dividing it into so many steps, it sounds like a staircase, is a motion to disclose the records to an expert investigator or other third party. Could that other third party be the defendant? Suppose the lawyer says, look, I found this stuff and contradicts the victim, and it sort of supports what my guy says happened, at the incident. I need to sit down with him and show him this. Now, of course, one of the big problems with this whole issue has been, under Stockhammer, defendants are going to be combing through these records, perhaps. So does that thing preserve or refer a defendant possibly looking at these things until there's a judicial order later? How do you read it?
First, let me state, I'm here seeking Mr. Dwyer, getting him a new trial. I spent substantial time with his case, and I appreciate that I have invited this hornet's nest by my DAR application. I have read the protocols. I realize there's been numerous amicus briefs. I have not been able to read them and address every argument raised in them. I will try to address your question. I think the language that you read, it says or any other person, clearly would include a defendant. It certainly does not exclude a defendant. But I agree, out of the experts and other people that you would potentially show these records to, the defendant is probably the most important person you would have to show them to. Because I know in my job, I've read records and they have no significance to me whatsoever, and I can show it to my client, and they can tell me 5 different reasons why that's helpful to their case. It's not because I'm not prepared, it's because I might not have all the information that's in their head. So I think at some point in time...
So you'd agree with me that showing it to the defendant is postponed until that point?
I agree. I think the first step needs to be, rather than just having an in-camera review by just the trial judge, that you have to have a review by defense counsel and the Commonwealth.
When you say in-camera review, where in Protocol C does it say? I must be missing. I don't see where it says an in-camera review in the C.
Your Honor, I apologize. I don't actually have those with me.
It's in the clerk's office, as I understand it, which is really not in-camera in the traditional sense.
When I say in-camera, I mean some sort of a closed setting. You're not allowed
okay, but it's not the judge doing it himself or herself.
That's right.
Okay.
That's right. And you're not allowed to photocopy the records. You're allowed to take notes, because obviously our memories are not as perfect.
And at that time, the protective order would say, and you cannot show anything to the defendant or discuss it with him.
That's correct.
Until when?
Until further permission by the court.
In
which case you have to go to the court and say, I've seen certain entries in these records. I'm not sure what they mean to me, but something in my mind is telling me they might be relevant and exculpatory, and I ask the court's permission.
But isn't that going to apply to just about everything based on what you just said? You look at records, you say they don't mean anything to you, but then when you discuss them all with the defendant, he, she tells you, they're important in ways that you haven't envisioned. So if you don't know why something might, or if something might be helpful, how are you going to persuade the judge that it might be helpful?
Well, if you know your case well, you're going to be able to know when you see something that's got some potential relevancy. It's not like you're going to read it and just read right over it.
And are you going to have to disclose that to the judge and to the Commonwealth?
You can have a closed session with the judge. I know in this case...
Can you think of any circumstance when you're not going to want a closed session with the judge?
When I'm not...
Ex parte. In other words, defense counsel says, I think I smell a rat here. Mm-hmm. Is defense counsel going to want to give that to the Commonwealth?
Not necessarily, and I think it's Commonwealth versus Mitchell. This Court addressed the fact that you can have ex parte motions before the judge if something in the affidavit, your proffer, is going to be incriminating. So I do think there is a procedure that this Court has already set up for some sort of an ex parte process.
Can I ask you a question? Can we move to the case itself?
I would love to.
All right. But to start with this question, I really did not understand from your brief that, in fact, Drs. Allen and Michael, are those the two doctors?
Jeannie Michael and Dr. Prudence Allen, yes.
Okay. That subpoenas hadn't even been issued for those records. So the Lampron standard of relevance wasn't met? Was that the ruling?
It wasn't that the Lampron standard wasn't met, and Lampron obviously wasn't in existence at the time, but it was that, and if I can find
the judge made a determination that those wouldn't be issued.
I'm looking at my wrong book.
So they were never brought to court?
They were never brought to court. There was the judge assumed that they would have been privileged because there was a medical record attached to the proffer which identified Dr. Prudence Allen as a psychiatrist and identified Jeannie Michaels as a psychotherapist. And from reading that, the judge said, I can determine that these are privileged records under 233 Section 20B, and therefore I'm not even going to issue the subpoenas.
So therefore what? So they're privileged and you have not made an adequate showing under Bishop Fuller even to require me to look at them in camera? Was that basically the judge's ruling?
That's basically, and actually there's an additional level of error here because when the records that were summoned came into court, the judge, and this is at Record Appendix 241, records came in from the Milford-Whitensville Regional Hospital, and the court said, these records were delivered to the court. They are confidential medical records, although no specific evidentiary privilege applies. The court has conducted an in-camera review of these records. They didn't contain any exculpatory information, and for this reason, the court will not order the disclosure of these records. That's directly contrary to Oliveira. Again, it goes back to if there's no privilege, then there's not a second screening of relevancy. Once you've met the Stage 1 relevancy, they go directly to counsel. So that was an additional error.
Now, at the trial of the co-defendant, is that right?
There were actually two trials. He was tried immediately after Mr. Dwyer. There was a hung jury on all 11 counts, and then he was tried again.
And in between that time, another judge heard another motion under Bishop Fuller?
Right before the second trial of Mr. Lamberto, Judge Borenstein reconsidered the motion and allowed it at that point. And the records came in at the beginning of trial.
And the judge reviewed those records in camera?
The judge reviewed those records in camera, determined that they were discoverable, allowed defense counsel access to those records.
And there's no question that those records were privileged, correct?
That's correct, because they were governed by those Section 20.
Yeah, Dr. Allen and Dr. Michael.
Were they governed by 233-20J?
No, they were 233 Section 20B.
Psychotherapist privilege.
Psychotherapist and, yes.
I'm also on the case. I have a question on a different aspect of the case, the statement of the co-defendant, which was admitted.
Yes.
To impeach. Why was that not inadmissible hearsay? I understand the co-defendant could have gotten up on the stand and testified, but you couldn't get him because he was waiting trial. But why was his statement admissible anyway? Why wasn't it just plain hearsay?
I would agree with you. I think there were a number of reasons.
Was that raised to the trial judge?
It was not. The objection was that this statement had been suppressed. It wasn't suppressed because of he hadn't been read his Miranda rights because it was a statement to a civilian, but it was suppressed because it was determined to be coercive, involuntary, and unreliable. And so I'm not here seeking to assert Mr. Lamberto's constitutional rights, but I think Mr. Dwyer has a constitutional right to due process and to be convicted of reliable evidence.
Right, but inadmissible hearsay shouldn't come in anyway, and that's plainly
there's an additional
is.
basis why it should not have come in.
But it didn't come in as substantive evidence, did it?
No, it didn't, but the limiting instruction that was given was not very strong in this area either. I think.
But it came in cross-examination. I think on direct examination, Mr. Dwyer was asked whether he had any knowledge of Mr. Lamberto's involvement or something like that, and he said no. So on cross-examination, he was asked, well, in essence, didn't you know that Mr. Lamberto admitted to this?
But actually, Your Honor, the way it came out, it's a subtle distinction, but I don't think the latter statement was impeachment evidence. He testified, he was asked on direct examination, do you have any knowledge of whether Mr. Lamberto abused the victim? He truthfully answered no, because to this day he continues to believe that nothing happened for him or Mr. Lamberto. That's different from the Commonwealth's question, which was, are you aware of whether or not Mr. Lamberto has admitted to making the statement that he had abused the complainant? The distinction is that you can still not know, you can still say he didn't do it, but still be aware that there was a suppressed confession out there.
Well, that's cutting it pretty close. I mean, isn't this sort of a discretionary matter for the judge to decide? I mean, you're saying, well, his answer really was a little different, therefore cross-examination had to be just sliced just right. But I'm not sure. I don't see that in this case.
The trial judge's reaction to this was actually very interesting. She very forcefully said, that can't come in. Her initial reaction was, she said, that's suppressed, that can't come in. Mm-hmm. And about 3 pages later, after the Commonwealth continued to fight for this, she finally said it can come in as impeachment evidence.
But even impeachment evidence has to be admissible evidence on its own, so this is inadmissible hearsay.
I agree. I think there are numerous reasons why this should not have come in.
But that was not brought to us.
So I take it was offered to show that Dwyer knew that Lamberto had implicated him in his confession. Isn't that the purpose for the admission of Lamberto's confession?
Well, over the defendant's objection, the Commonwealth kept intertwining Mr. Lamberto and Sean Dwyer in this case. So much of the testimony elicited from the complainant was, I was raped by my 2 cousins. The prior bad act evidence came in, my 2 cousins. So I think the Commonwealth wanted to get before the jury, whether or not it implicated Mr. Dwyer or not, they wanted to get before the jury that Mr. Lamberto had admitted it because there had been so much evidence that there would be a presumption that Mr. Dwyer was guilty too if Mr. Lamberto.
But wasn't the only relevance that Dwyer knew that Lamberto had implicated him? Isn't that the only relevance to the confession?
It wasn't that he had been implicated. It was that Mr. Lamberto had admitted to his own role.
Right, and it seems to me that wouldn't have been permissible
if
the door hadn't been opened on direct examination by asking the question, do you have any, do you know whether any knowledge of whether Mr. Lamberto was involved? And Dwyer says no, and cross-examination is, well, wait a second. Don't you know that Mr. Lamberto admitted to this? Oh, well, yeah, but it was a forced admission. I mean, isn't that?
Because it's a forced admission, it means it's unreliable, which means you can't be impeached by that. This Court has said and other courts have said just because a statement is used for impeachment purposes doesn't mean it's any more reliable than if it's used for substantive purposes. So it shouldn't have come in for impeachment whether it was valid impeachment evidence or it wasn't valid impeachment evidence. And the Commonwealth tried to capitalize on this. The Commonwealth is arguing they had a really strong case, but if they did, they didn't need to push the envelope on these really thorny issues. The Commonwealth then capitalized on this in their closing argument. They asked for a missing, during their cross-examination of Mr. Dwyer, after he said, well, yes, he said that, but he was forced to. And the next question is, oh, so now you're saying he admitted it, but he was forced to. So suggesting that he was making up the fact that he was forced to do this. The Commonwealth knew that he had been forced to. The Commonwealth knew that Mr. Dwyer's testimony in this respect was truthful, that he had been forced to. But the way it came out suggested that he was making up the fact that it was forced out of him. You see, I've moved around from the bishop to this statement.
Now, I take it your position is that in this case we have a relatively clear sort of set of circumstances that explains what difference it makes to get access to these records.
Absolutely.
Correct?
I mean, the one argument I really haven't heard is that the records didn't contain exculpatory information.
And you say that it's exculpatory because there were so many statements by her that she had been raped by the two boys when she was younger, and therefore they were under 17.
That's right. Her trial testimony was that she was raped for a 5-year period of time between the ages of 8 and 13. And the 13 was the magic number because that made the defendants 17. The first SANE interview, she was asked, did any of the rapes happen at your home? And she unequivocally said no, because the defendants were afraid of my father. Well, lo and behold, I suspect she found out that there was no charges for when the defendant was 17. So she then made up the July 1997 incident, which happened to have occurred at her house.
But you knew that the charges were that she had been raped or sexually abused between 8 and 13. So your clients knew that they were under 17, at least one during the time she was 8 to 12.
Yes, and those came in as prior bad acts.
Yeah, that's another question, but forget that. But why couldn't you – but did the indictment read between the time she was 8 and 13? Or those dates?
No, it did not. I mean,
it only read on the two dates in 19, what was it?
There was actually not
97 or
specific
whatever it
dates
was.
because she said it was the week before my birthday. in
So
July.
there were no charges related to the prior times.
That's right. But the fact that she says in her therapy records that the rape only happened for 2 years between the ages of 8 and 10, and all of a sudden we have these allegations coming out saying, oh, it happened for 5 years, that's a substantial discrepancy. And our position is nothing happened at all. But if the jury did believe that something happened, hearing that she's made up different stories as to when she was raped, and this is a 3-year difference, so that's a substantial difference, would have been exculpatory because it bears on her credibility. And her credibility was the sole issue in this case.
How old was this child when she was, for the first SANE interview?
It occurred in May of 2001.
17, maybe?
I'm not good at math. I think that sounds right.
I think it may be 17.
That sounds right.
Because it was a 4-year delay in disclosure.
That's right. That's right. I see that my red light's been flashing for a while. There are a number of other issues in the case I obviously can't address. The issue of the missing witness instruction is a very substantial issue, and I appreciate the Court's time.
Thank you, Ms. Pennell. Ms. Kukofka?
Good morning, Your Honors. Varsha Kukofka for the Commonwealth. 5 judges made 6 different rulings on the Prudence Allen records, the Jean Michaels records, and the Pembroke Hospital records. And they were all consistent, and they were all successfully under the Bishop protocol to allow what proffers had been before them. One judge that was not mentioned is that Judge Burns, before Judge Bornstein, was asked by the co-defendant to get those records again, and Judge Burns, and I have the ruling, if the Court wishes me to file it, I'd be glad to, but it is in the docket that's part of the record, Judge Burns' ruling, that Judge Healy had already ruled on the Pembroke Hospital. He had followed the Bishop Fuller protocol, stage 2, properly. So what you have is Judge Kratzley saying that the defendant had not made the proper showing. In fact, there was no affidavit with that first motion to compel. All that was offered was a 2-page document from the UMass Medical Center of the physical examination of the victim. Judge Kratzley said that the Prudence Allen and Jean Michaels were privileged and that the stage 2 showing had not been met. Judge Healy then ruled on the Pembroke Hospital records and said, and Judge Kratzley had said as to Pembroke, there may be some relevance. I'll wait until I decide. Judge Healy then got the next stage of it, and he did decide, and Pembroke Hospital filed an affidavit asserting the privileges, all in accordance with the Bishop Fuller protocol. And the affidavit was provided to the defense counsel, redacted names. Judge Healy said that it did not meet the stage 2 standard. before the and the defendant did not raise the issue again at his trial. At the co-defendant's first trial, he moved again. Now, this is the third judge ruling on this same affidavit that came from Attorney Rones, only when it came to Judge Healy, not before. Judge Dorchokara at the co-defendant's first trial said, no, you may not have the records.
Judge
Burns.
Let me interrupt you for a minute. You may be absolutely right about this, but it seems to me what the defendant is saying is that unless they get a chance to look at those records without having to make that kind of a showing, they would never have known that this exculpatory material was in these records. The widely disparate statements about when these incidents occurred that could have been used to impeach her credibility.
They are making that argument, but it's wrong, because they had the information in the 209A complaint and in the 51A report that was later produced by Attorney Rones for Judge Bornstein. I'm saying Dwyer's attorney had this information through discovery. In fact, he
had what information?
He had information that the dates provided were 92 to 95, not 97, in these two records.
But isn't that just an accident in this case? I mean, doesn't this case show, just like Sheehan, I think it was Sheehan, where we just find out after the fact that there's all this material that's useful to the defendant, crucial to the defendant, and we don't find it out in the normal case because of the impediment of the bishop with the Fuller overlay on it?
No, Your Honor. It's a choice that the defense counsel makes as to how to go ahead with their defense theory. He questioned the victim's mother, well, didn't you put down 92 to 95 in that complaint application? He was aware of it. He didn't want to go with the defense theory that my client was under age 17 when he did all these sexual assaults, like Lombardo's attorney finally did coming up to the second trial.
I'm conceding. Maybe you're right in this case, that in this case there was some other way of finding out that material. Forget this case. Let's assume you're right and Commonwealth will win. So put that aside. But in the ordinary case, isn't there all this material that the defendants can't get at? And here there was a way for them to get at it. But what about the routine case where they have to show that it's relevant and material, and yet they don't know what's in it, in the records, to be relevant and material?
They have to get through the Lampron showing, specificity, necessity, admissibility, and relevance.
Right, but then they also have to get through the stage 2 of Bishop Fuller.
Right, they've got to show it's exculpatory and not available to them elsewhere. So if it's available elsewhere, the Fuller standard says you can't get the records.
Well, if
I mean, there is this paradox built into that standard.
But if you turn it around the other way, which is one of the principles that the committee had in mind, is that it's important to encourage reporting of rapes, and it's important to support victims getting treatment, and that it's critical that they get the treatment, then you say any time a victim goes for treatment after disclosure or after the rape, there could be something in there that I don't know about. And I have the right to find out, because that would be the mere relevance standard, wouldn't it? I mean, the court has said, and why
well, there could be. I mean, make it as simple as you can. Suppose that when the victim went, this is a ridiculous example, but I'm just trying to make it very simple. Suppose she goes and she says, I was raped by a black man, and she tells that to the sexual assault counselor, and the Commonwealth gets a white man as the defendant. I mean, shouldn't the defendant be able to see that?
Well, how would he be able to see it when she has a privilege of speaking confidentially?
But isn't that absolutely key to his defense?
First of all, most of these filings are made in the context where the parties are known to each other rather than strangers.
You can't say most. Right? I mean, when you talk about most, you're talking primarily, I think, about interfamilial rapes, correct?
Some relationship.
Some relationship. That happens quite often with children, right? And it seems to me that this raises
and adults and adolescents.
But to say most rapes,
I mean, the example of someone saying that it was a black person and not a white person.
I just give that to make it easy.
Well, it's such an extreme example, Your Honor, that anything can happen. It's
There
kind
are
of
all
in the realm.
variations of that. I
Ms.
mean, you can-
Kukafka, one of the problems here, it seems to me, is whether or not there has been a rape as opposed to evidence where there is a rape and the question is identification. And those are two very different sets of circumstances. And the one that Justice Cowan is suggesting is not one that is an interfamilial or the alleged attacker is known to the victim. But whatever rule we have has to apply in both sets of cases.
Well, the threshold has to be that there has to be something that shows the victim's, inability to recall, inability to perceive a prior false accusation.
But how do you show that if you don't know what there is in the record that will show that she was unable to perceive?
Well, that's the defendant's burden. That's why there are the privileges and the protection of the victim's privacy.
Mr. Kukafka, let me ask you this question, because I am frankly perplexed at the Commonwealth's position here, because it seems to say there is a privilege, but it's possible to break that privilege, correct?
Under the Bishop Fuller Protocol.
And you're not challenging that. Take a case, this case. The victim is 17, as I understand it, when she has a SANE interview, correct?
16.
16, 17. 17, 18. And she consults an attorney. She wants to know whether or not there's a civil action that she can bring against her cousins. And she goes to the attorney's office and she consults that attorney. And she lays out a whole set of facts, correct? And somehow, because this is all interfamilial, it becomes known to the defendant. Is it the Commonwealth's position that provided the defendant can show relevancy and heightened standards, that he gets access to that information?
Her discussions with her attorney?
Correct. Seeking legal advice. She goes for the specific purpose to seek legal advice.
Well, we're figuring this is pre-trial and that it would have something to do...
I've just given you the facts. Of course it's pre-trial, because if it were post-trial, this is pre-trial. She's doing two things. She's telling the Commonwealth, and the Commonwealth can decide whether or not the Commonwealth wants to indict, but she's also pursuing a civil action. Is it the Commonwealth's position that those records fall under Bishop Fuller?
No, not at all.
Why not?
Well, these cases came down through the U.S. Supreme Court cases and to our whole jurisprudence of two juveniles, a legitimate need. It was all in the context of mental health records. It was not in the context of an attorney-client privilege. And so all of the
But what if there were a case involving attorney-client privileges?
What I'm saying to you is, what is the difference? You say in the context. Privileged communications under 233.20J are really quite specific. They are quite specific. Those are not psychotherapy going back. They're not SANE interviews. This is a rape victim who, in the wake of a rape, consults somebody that the legislature has determined may be absolutely essential for her survival. And I'm simply trying to figure out where the Commonwealth is on privilege, why the Commonwealth draws a distinction between, quote, mental health, sort of rolling them all into one, and any other privilege.
Well, there is a distinction between a right to privacy and the statutory privileges that were brought to encourage that right and support that right to privacy. It's a different line than the attorney-client privilege. You also have the Health Insurance Portability and Accountability Act as to that glosses over when these records can be even released. I mean, there's a whole, these people are holding the records for the witness or the victim.
But they're discussing this. In one case, the person is going to discuss a particular subject with a lawyer for a certain remedy. In another instance, that same person is going to discuss exactly the same subject with a doctor, also to seek a remedy, a different kind of a remedy, to be cured as opposed to get money to make them whole in that way. Why should the conversation with the lawyer enjoy any greater protection than the conversation with the doctor?
Or put the other way, why should the conversation with the doctor draw any less protection than the conversation with the lawyer?
Less protection? I don't think it necessarily has less protection.
Well, you've just told me it has less protection. You've said...
I said it has a different protection. It has a whole separate line of analysis. And because the importance of encouraging people to report crimes has the purpose of the statutory privileges is that is one of the reasons, the underreporting of rapes. That's a whole different realm from a civil action. It has nothing to do with it.
Could I ask you that? I mean, one of the things that has troubled me about this is we're dealing here with legislatively created privileges. All the mental health privileges are legislatively created. And the legislature could create all kinds of privileges. We have terrible problems with witness intimidation and retaliation against informants. Legislature could come out and say statements made by informants are absolutely privileged. Statements made by witnesses to the police are absolutely privileged. You know, upsetting all of our jurisprudence about when and under what circumstances defendants get access to those statements. What do we do then? Do we just go, oh, legislature has said it's privileged, too bad, defendant?
Well, the defendant's right to a fair trial, it could come in the way it has in this, is that to prevent an erroneous conviction.
How would the defendant know? How would the defendant know? There's a statement that's been given by an informant, for, as Justice Osman suggests, for very compelling reasons, is privileged. The legislature says it's privileged because one thing we can take judicial notice of is if that information is known out on the street, the person's life is at risk. So the defendant knows a statement has been given by an informant, doesn't know what, doesn't know whether the informant said there were 2 people, 3 people, they were 250 pounds or 110 pounds, doesn't know if he said they were women or men, doesn't know if he identifies them by name.
My suggestion is that were that to be the case, this court would have to address it through a defendant's presentation that he was denied access to something that would create a reasonable doubt that was not otherwise there, to pierce that statutory absolute privilege, which exists in other forms. I'm just saying that this is not equivalent, and hypotheticals are not what we have in this whole Bishop Fuller protocol and jurisprudence, which has been hailed by just last year in spring, University of Pennsylvania Law Review article, Texas Law Review article. The Bishop Fuller protocol is the model. You know, it prevents wrongful convictions. It allows the privacy of the victims. It balances the defendant's right to a fair trial by going through these stages. It's held up as a model to the rest of the country. There's nothing wrong with it, and this is how it worked in this case. The defense theory changed, and all of the judges, including Judge McHugh in the motion to stay, agreed that there was no merit to the claim that these judges had abused their discretion.
Well, the defense theory changed after this information became available after Mr. Dwyer's trial.
But I'm saying the underlying...
If it had been disclosed at the beginning, maybe the defense theory would have been different from day one.
He had the information, though. He brought it to his own trial. Dwyer did. He cross-examined the mother. Didn't you fill out the application that said...
Well, cross-examine the mother, but we're talking about statements made by the complainant, the key witness in the case.
If you look at the... And that's why I moved to expand the record, and I hope this Court will allow that motion. You will see that, first of all, you can see in the record itself excuse me, Your Honors, 1 second. On the Record Appendix 257, all of the Pembroke Hospital information, the relationship of the informant is M.O., that's the mother.
All right, well, I thought we were talking about, are
Let's
those the same records as Dr. Allen and Dr. Michael? Which
No,
is
Pembroke Hospital is several pages.
Right. But
Prudence Allen will say in Lamberto's trial, she didn't ask the victim when this happened. She was dealing with her medication, her sleep deprivation, and so forth. She was referred to her by Jean Michaels, who was her therapist. Look at the Jean Michaels records. They are consistent with what the victim said, that it stopped when she was 13 and they were 17 because she started menstruating.
Ms. Kukafka, let me ask you this. With respect to this case, I take it, and I will accept that if we look carefully, you would say two different attorneys, one had one strategy, another had another strategy. They both had access to the same information out of the gate that would have permitted them, had they pursued it, to end up with the same records. Is that correct?
That's exactly correct.
What do we do with the ineffective assistance of counsel claim?
Well, ineffective because he didn't pursue putting before the jury that this happened before his client was 17 years old. That's a reasonable tactical decision to say this never happened. It's perfectly reasonable. In fact, it's probably preferable to say none of this ever happened than to say, well, it happened, but I wasn't that age when it happened.
Let me just ask you this. He may have decided to do that at trial, having looked at the records. But he didn't. This is pre-trial. In other words, if you have the information and you decide not to use it, that's a very clear tactical decision. But if you are exploring how to develop your trial strategy and there's something that is jumping out at you from the records, why would you not pursue getting those records? You don't have to use them.
Well, what I'm saying is he had the 51A and the 209A information.
those are statements of the mother, right?
Well, the 51A was the victim and her mother talking to the guidance counselor. So he certainly, and the assumption could be that what the mother wrote down in the application came through the victim, 92 to 95, certainly. I mean, where else would she get it from? So that was available to him. He did not pursue that defense, and that's why the defense theory has to be tied in order to get the records. There has to be a link. There has to be a substantial showing to pierce these privileges.
I have a question about the trial. The Prior Bad Act evidence from all these past years came in. What does the Prior Bad Act evidence prove here?
The Prior Bad Act evidence was essential to prove why the girl had not disclosed. She had been led through this path from the age of 8, that if you tell anyone, they won't believe you, and it will destroy the family. And it was important to show how this happened little by little and over all of these years, that she would hold this into herself as a secret. It was also, of course, important for other reasons, as Judge Dorchakar said in her ruling on the motion for new trial.
But did the defendant say that at the time of did the victims say that the defendant said that at the time of the 2 charged acts also?
At the time of those rapes, I don't believe that she said that was a statement made at that moment, but that was her state of mind as far as her relationship with them and all of these sexual assaults, that she kept it to herself. So she went upstairs and her mother came home with birthday gifts, and she said Sean was here and she didn't tell. And she came out of the garage and said nothing, because she had been groomed
Excuse me.
to keep this to herself. And that's why the bad acts were important. That was one of the key reasons.
Can I ask you this question? You just said to me that the records that were subsequently disclosed in the co-defendant's second trial really weren't very helpful. There's nothing exculpatory in them. Defense counsel in their brief says the complainant's records, talking about these very records, contain numerous references to the alleged abuse only occurring for a 2-year period when the complainant was between ages of 8 and 10. So that's not accurate?
It's accurate that that's written in the Pembroke Hospital.
Okay. And that's one of the three. It's Dr. Allen, Dr. Michaels, and the Pembroke Hospital records are the three sets of records?
And that's another reason I'd ask this court
Okay.
to expand the record, because when the mother is questioned at the second trial of Lamberto, a lot is asked about the Pembroke Hospital admission. The girl was in dire straits, and the mother was frantic, and she took her there, and she was put into a locked ward for 2 days, and the mother provided the information, and that she was also told not to talk to her daughter, not to ask her daughter to question her, to let her be. And so
just so I'm clear about your position, there is nothing in Dr. Allen's records or Dr. Michael's records, the two psychotherapists, that is exculpatory in any sense, or was even used at the second trial of the co-defendant?
Dr. Allen, well, all of these were exhibits at the co-defendant's trial.
Oh, so they were used at the
They were
co-defendant's trial?
exhibits. They were heavily redacted, and in fact, it's important to know that Judge Bornstein only allowed in the age because that was the proffer that was made. So all of the other proffer, you see that nothing came out of it except the age.
The age at which it allegedly ceased.
I'm sorry, Your Honor?
The age at which the events allegedly no longer took place.
The age at which the defendants stopped raping the girl, yes.
Yeah.
Thank you, Your Honors. I will rest on my brief for the other issues.